Good day, everyone, and welcome to today's Fair Work Ombudsman webinar, Know Your Rights at Work for Young Workers and International Students. My name is Ryan, and it is a pleasure to be talking with you all today, whether you're joining us live or viewing the webinar on Catch Up through our YouTube channel. And of course, welcome to Semester 2. So today's session is about giving you the essential information you need to know about your workplace rights, including what to look out for and where to get help if things go wrong. Many of you may already be working or planning to work while you are studying, and a lot of you may already be looking to work on student visas. Either way, you will have the same rights at work, and it is important to know these rights. For those of you who did join us for our first semester session, we will cover a lot of the same information. However, there are a few updates as well, including information on the gig economy, new minimum wages, and some upcoming changes to junior wages as well. And don't worry, we won't be deep diving into the legislation or looking at the history of workplace rights in this country, 8-hour day and all of that, nothing like that. I'm going to keep this as practical and as useful for you as possible. And also, don't worry about taking notes on website addresses or any of the tools or resources mentioned in the webinar today. For those who have registered, you will receive an email after the session with a bunch of links to the information that we cover today. If you are watching on Catch Up or on YouTube, you'll be able to access the links in the description below, so check those out as well. Now, we won't be directly answering questions in the presentation today, but we do have a couple of our helpers in the Q&A section of the webinar. So if you do have any questions, please pop your question into the Q&A portal, and they're going to be able to help you, point you in the right direction where applicable. If you do have issues or complaints that you might have, that are relevant to your personal scenario as well, probably worth getting in contact with our info line, as we won't be able to do much around like assisting you resolving matters through this channel. So the best place to call is on our Fair Work info line, which is 131394, or you can visit our website at fairwork.gov.au. But before we get into the main presentation, I'd first like to acknowledge the spirit of reconciliation of the traditional custodians of country throughout Australia and their continuing connection to land, waters, skies and communities. We pay our respect to their elders past and present, and we extend that respect to all Aboriginal and Torres Strait Islander peoples today. So I'm presenting from Wurundjeri country today in Naarm or Melbourne. Okay, let's begin our journey into your workplace rights and entitlements. So I'm going to start with a little introduction about the Fair Work Ombudsman, or the FLO as we call ourselves. So I'll talk about what we do, how we can help, and hopefully most of you have at least heard of us. So in Australia, all employees have rights protected by workplace laws. These laws apply to everyone, including young workers, visa holders and international students, regardless of the visa type or length of their stay. The Fair Work Ombudsman is Australia's independent national workplace regulator. We provide free, impartial advice, education and support to employees, employers and organisations. We help resolve workplace issues and offer tailored tools and resources for all employees, including young people and international students like yourselves. Now, we have different responsibilities as well from the Fair Work Commission and the Department of Home Affairs, particularly those of you who are international students. You may be aware of the Department of Home Affairs. They look after your visa conditions and things like how much work you can do, how many hours you can work, and when qualifies as like on study or off study time. So if you have questions about those, you're best directing those to the Department of Home Affairs as well. Okay, so as I mentioned at the top, I expect you are attending today because you are either already working or seeking to work while you undertake your studies. And they say that the best protection against workplace issues is knowledge of your rights. So what do you need to know when you first start a job? So the first thing you want to understand is what your minimum entitlements are. When you first start any job, your new employer is required to provide you with a copy of the Fair Work Information Statement, which contains a bunch of really useful information, including the National Employment Standards, which provide all workers in Australia with a safety net of minimum entitlements. The National Employment Standards covers things like annual leave or holiday pay, personal and carers leave or sick leave, covers paid family and domestic violence leave, maximum hours of work, and things like public holidays as well. And we'll have a look at the Fair Work Information Statement a little bit more closely shortly. And if you have started work and you haven't been provided one yet, I'll show you where you can access this document as well. Now, when you start work, there are two important things to clarify with your employer. The first is whether you're going to be full-time, part-time, or casual. Now, most of you, as you will be studying, will likely fall into the categories of either part-time or casual. And depending on which one of these you are, there can be very different conditions and even wages, which I will touch on shortly as well. The second thing that it's important to clarify up front is which award or enterprise agreement you'll be covered by, because these will determine what you're actually entitled to. So an award, put simply, is like a rule book of conditions for a whole industry, such as retail, hospitality, childcare, things like that, or an occupation. So, for example, nurses or teachers have their own award. There are over 100 modern awards that apply to most Australian workers. And what they do is they break down your minimum entitlements, such as minimum pay per hour based on the type of work that you're performing, things like penalty rates, so when you work weekends or nights or public holidays. They look at when breaks can be taken, overtime rates, so when you're working above or outside of your ordinary hours, and things like allowances. So if you've got to wear a uniform or you've got to provide your own tools, things like that, there can be allowances to compensate that as well. Now, these terms apply automatically, even if you don't sign a contract. If your job fits within an award, it will set your pay and entitlements automatically. An agreement, on the other hand, a registered agreement, is like a rule book created just for your workplace or group of workplaces. If your workplace has an enterprise agreement, it will apply instead of the relevant award. So what's the difference? Well, an agreement is negotiated between the employer and the employees, and often sometimes their representatives like unions or employer associations. It must be approved by the Fair Work Commission to ensure that it is legal and fair, and it must leave you better off overall than the award, so you don't lose out. So while it can still provide minimum entitlements like the awards, it can offer things like higher pay, different rostering arrangements, or things like extra leave or benefits as well. So once you know whether you're full-time, part-time, or casual, and you know which award covers you, you can find out what your minimum rate of pay is. And we'll have a look at the minimum rates a little bit later. But how about paperwork? What do you need to receive? So pay slips are mandatory, which means you've got to receive them. And you must be provided these by the employer no later than 1 day after payday. Now, these pay slips can be provided online, either via your email or through like an internet portal or like a company systems, or provided in writing, so actually handed to you as a piece of paper. Regardless of how they are given to you, though, they have to contain the same information. But are pay slips important? Well, yes. So pay slips are your evidence of how many hours that you have worked and how much money you have been paid for the work that you've done. They help you check you've been paid correctly, and if there are any issues or mistakes, payslips can be used as proof in any action or investigation taken to rectify any issues. How about contracts? Do you need to receive a contract before you start work? So contracts are not a legal requirement under the Fair Work legislation, but they can be very handy in providing you with some important information ahead of starting your employment. Even a letter of offer can sometimes provide important information about your role. So whether you have a contract or not, the award or agreement conditions will still apply automatically, and a contract cannot make you agree to less than the terms of the award or agreement. So whether you are receiving a contract or a letter of offer or you aren't, we've put together a list of the important information that you want to get when you are starting a job. So the first thing we would recommend is that you know what your employer's name, Australian business number or ABN, and the location of the business is, especially if you are taking on the kind of work that is working away from the normal premises, such as contract cleaning work or on site labouring jobs. If anything goes wrong, this information will help the Fair Work Ombudsman to provide you with the information and assistance that you have if you have a workplace issue, like an underpayment of wages. Now, the other thing you'd want to know, apart from turning up on time and making a good impression, it is important to know your work schedule or roster so that you know what you're meant to be paid, especially if you are part-time. Now, are you going to be working weekends? Are you going to be working evenings or early mornings? These hours may attract penalty rates, which I talked about from the award, or even sometimes overtime rates if you are required to work past those hours, and that can give you a higher rate of pay. If you are part-time, you should expect to have regular hours and often the same shifts every week that do not change. You'll need to confirm your right to regular shifts in your award or agreement, though. Similarly, really important to know what your regular duties and responsibilities will be, because this is important as it can help to determine what classification level you are under an award and what level you were paid at. So again, that's something else that can affect your minimum pay rate and even sometimes allowances. Now, we've already talked about the importance of pay slips, but it's also important to make sure that the money you are receiving matches what is actually provided on the pay slips. So if you are going to be paid into a bank account, make sure to check that the amount listed on your pay slip is what is actually going into your bank account. Now, some of you might be paid in cash, and I just want to say from the outset, it's not against the law to be paid in cash, so in monetary currency. There is a difference, however, between being paid in cash and receiving what we call cash in hand. So if you're paid cash, it is important to make sure that you are on the books, meaning that your employer is keeping employment records and they are meeting their obligations like tax and superannuation, and they are providing pay slips. If you're not being paid on the books and receiving cash in hand payments, so that's where you're being paid in cash, but the employer's not keeping any records. You might not be getting any leave or anything like that. You're just getting cash for the hours that you work. If things go wrong, you still have the protections of the Fair Work Act, and the Fair Work Ombudsman can still assist. And even if you're not getting a pay slip, we can still help you. But we would say if that's the case, it's always really, really good idea just to make sure you are keeping your own records. And as I said earlier, as soon as you start work, if not beforehand, you need to receive a Fair Work information statement. And if you are casual, you need to receive the casual employment information statement as well. So let's have a closer look at the Fair Work information statement now. Okay, so this is on the screen now. You can see the Fair Work information statement. The reason why this document is so important is that it does tie together a lot of the basic information that we have discussed so far, such as things like the national employment standards, difference between awards and agreements, minimum wages, and other entitlements that are in a single document that also includes details on how to seek help if things go wrong. So please make sure you actually read it. I know it's very easy to throw paperwork away when you receive it, and we get a lot of it when we start new jobs, but this is a very important one. So if you are seeing this one, keep a hold of it and make sure you are going through it. As I said, your employer must provide you with this document when you start work, but if you haven't received it, you can get a copy of this from our website at fairwork.gov.au/FWIS for Fair Work Information Statement. And this is the best place to get the most up-to-date version, as any changes to legislation or minimum wages can affect the document. And this document is definitely worth, as I said, keeping hold of with any other work records you receive. Now, like I said at the start, going to give you a few links as we go through this, but remember, if you are watching live, you'll receive the email with these links in it afterwards. If you are watching the recording, they'll be in the description of the YouTube video down below. All right, so let's have a look at the different types of employment. So we talked a bit earlier about particularly the confusion between part-time and casual. So I wanted to go through and have a look at the difference between the three different types. Starting with full-time. So full-timers will usually work 38 hours or more a week, but 38 hours is the ordinary hours, and they are paid for a full week. Part-timers, as I said earlier, they work regular and systematic hours each week. They're just working fewer hours than full-time employees, so anything under 38 essentially. Now, both full-time and part-time employees both get paid annual and personal leave or sick leave. Part-time leave is calculated on a pro rata basis, which basically means the number of hours or days leave you get will be proportionate to the amount of hours you actually work. So as an example, full-timers and part-timers, they get 4 weeks of annual leave each year as a guide. If you're a full-timer, you get 4 weeks of 38 hours. If you're a part-timer and you're only working 25 hours a week, you still get 4 weeks of the annual leave, but it's 4 weeks of 25 hours. Now, both full-time and part-time will give you an entitlement to notice of termination, meaning that you've got to be provided with notice if you're being terminated, or you have to give notice to your employer if you're going to resign. And again, the amount of notice provided depends on actually how long you've been with the business and can depend from award to award. But generally, this comes from the National Employment Standards. And you're looking at someone who's worked less than a year has generally got to give 1 week's notice. Someone who might have worked from between 1 and 3 years would have to give 2 weeks' notice. And it goes up to about 4 weeks' notice. And like I said, that goes both ways. So if you're either resigning or you're being terminated, that notice still has to apply. Now, casual employees are a little bit different. So a person is a casual if at the start of their employment, but there's no firm advance commitment to ongoing work, and they're receiving a casual loading or a specific casual pay rate under an award, agreement, or contract. So as an example, someone might be a casual if their roster changes weekly to suit the employee's needs. So that means some weeks you could be working 30 hours, some weeks you could be working 0 hours. There's no guarantee to any work each week. You've also got the right to refuse shifts or to swap shifts, and you're getting paid a casual loading, which is a higher rate of pay to compensate for what you're not getting. Now, casuals don't get paid for holidays or sick leave, so when they take time off when they're sick, but they do still receive paid family and domestic violence leave, which is the same as part-time and full-time employees. You can find out more about family and domestic violence leave at fairwork.gov.au/FDVL for family and domestic violence leave. While we are on the topic of different types of employment, I thought it'd be worth looking at one of the emerging types of employment, particularly with international students. It's the gig economy, or employee-like workers, or what we call regulated workers. Okay, so this type of worker might be known as a contractor or a subby or an independent contractor as well. So for this section, we'll be using the blanket term contractor, but in legislation, they're also known as regulated workers or employee-like workers. Now, contracting, as I said, is common. It is on the rise, particularly amongst international students and young workers in what we call the gig economy, which connects service providers with consumers via apps or websites. So it's also known as the platform sharing or app economy, or the on-demand workforce. A lot of different names for essentially what is the same thing. So in the gig economy, people offer services for a fee through digital platforms or marketplaces. And some of the common gig economy services, particularly in Australia, are things like food delivery services, probably the most common that we see, ride sharing, so like your where you book a driver through an app. And there are some others where there's like fee-based personal service, so like engaging individuals for creative or professional or odd jobs around the house. Contractors in these industries may be considered as what we call regulated workers, and while they are still contractors, which means they are essentially their own business, they have additional rules and protections compared to your standard contractors who aren't regulated workers. And this has been achieved by the establishment of minimum standard orders or other types of guidelines. So there were some recent changes that were made by the Fair Work Commission about being able to set minimum standards for employee-like workers, and they can also handle disputes over unfair deactivations from digital platforms. Because these rules are fairly new and they are updating, we're continuing to develop more comprehensive resources as we go. But if you are interested in more information around the gig economy, the app-based economy, and being a regulated worker, I would recommend that you jump onto our website and go to fairwork.gov.au/contractors. There's a lot of information and there are changes ongoing, so definitely worth having a look at that. Now let's have a quick look at the minimum wage. Okay, so you might remember we discussed earlier that the minimum pay rates vary by job and that most employees are covered by awards or an enterprise agreement. These documents set their minimum wage as well. However, employees who are not covered by an award or agreement receive the national minimum wage, which has recently gone through a review and a subsequent increase on the 1st of July this year. So the national minimum wage has now increased to $1,004.90 per week, or $26.44 per hour for full-time or part-time staff, and the casual rate has now increased to $33.05 per hour. Minimum award rates have also increased by 4.75%, provided that the lowest rate in any award that applies to ongoing employment must be over the national minimum wage, as shown, for full-time and part-time staff. And any entry-level rate that applies to the first 6 months or less of employment must be at least $978.10 per week or $25.74 per hour. Now, it is important to note that these rates do get reviewed every year, and they are for people over the age of 21, so we'll cover up what happens with juniors next. But these rates will be set to increase or set for review next July 1st. Let's have a look now at earning below the minimum rate. So there are times when someone can be paid lawfully below the national minimum wage. And as we know, the national minimum wage only applies to employees not covered by an award or an agreement. It is also usually the lowest rate that applies an award. However, if you're someone who might be a junior employee, so somebody under the age of 21, and you are covered by an award or an agreement that contains junior rates, junior rates will apply. And these are usually based on a percentage for each birthday. So depending on your age, you get a percentage of that maximum wage. There are some upcoming changes, though, to people who are classified as juniors. So earlier in the year, the Fair Work Commission announced that there'd be upcoming changes to junior wages under the Retail Award, the Fast Food Award, and the Pharmacy Award. So at the moment, employees under the age of 21 covered by these awards are still paid that percentage of the adult pay rate for their classification and their age. But these changes mean that employers between the ages of 18 and 20 will be entitled to the adult pay rate for their classification if they've been employed by their employer for more than 6 months. Pay rates for employees aged 18 to 20 won't change if they've been employed for less than 6 months with their employer. There also would be no wage changes for employees under the age of 18. Now, these changes do not have an official date as of yet, but could start as early as 1st of December this year. So definitely worth keeping an eye on the website, particularly if you are looking at taking on some work over Christmas. You can also subscribe to updates on our website as well. There are other ways that you can be paid under the National Minimum Award. The second one is if you're undertaking an apprenticeship or a traineeship. So these are usually paid less than the national minimum wage, and this is due to them needing to complete paid training as part of their assigned coursework. Thirdly, employees who have a disability that have completed a formal skills assessment under the supported wage system may get a reduced award rate based on their productivity assessment. And lastly, some awards contain levels that are less than the national minimum wage, particularly if it's awards containing introductory pay rates for new employees in these industries. These lower rates tend to only apply for a limited time. And like I said, we said on the last slide, they're only slightly less than that minimum wage anyway. And after a limited time, you would progress to that minimum level or the next level into the award. So now we know about the minimum wages, we're going to have a look at some of the workplace myths and facts that we are seeing causing common issues in the workplace. And the first one we're going to look at is wages on trial. So sometimes an employer might ask you to do an unpaid work trial to evaluate you for a job that you're applying for. And this is used to determine if you're suitable for the job by getting you to demonstrate your skills. Now, unpaid work trials are only okay if it is solely for the purpose of you demonstrating the skills required for the job. So, for example, if you're looking at going for a job as a barista, an employer might look to assess your ability to make different types of coffee orders. You must be directly supervised, and the trial can only last as long as necessary for you to demonstrate that you have that required skill. If an employer wants to further assess your suitability after a trial, then they can employ you as a casual employee and or for a probationary period. And if the employer does this, you've got to be paid for all the hours worked. So as you can see on screen there, we've got Kevin who's applied for a job at his local cafe. In fact, it's pretty much exactly as the demo, the case study that we use. So he's going for a job as a coffee maker. His employer wants to see that he can make different coffee orders, so it gets him to run through a few different coffee orders. He's satisfied that he can do the job, so he employs him, starts paying him from immediately from that time, so he gets that job as a part-time barista. So the next one that we're looking at is paid for all hours. So similarly, once someone is formally employed by their employer, they must be paid for all work required to be done, including any compulsory training, whether that be in person, online or off-site, any after-hours team meetings, and any time spent opening or closing the business. So let's have a look at Emily's story here. So Emily works in a gift shop. Her boss tells her to come in 15 minutes before the store opens to set up. He says that she will only be paid for the hours the store is open. And so the boss is also asking her to stay back for an unpaid meeting as well. But she knows this doesn't sound right. So she gives the Fair Work info line a call and she confirms that she's got to be paid for all these hours. So she goes back to her boss and just explains that, this is what she's found out. Boss understands and agrees to pay her for those additional hours that she was required to work, including any time that she was in the meeting as well. So that's, got to be paid for all time that you're required to be at the business and working. Let's go to the next one. Okay, so this is money talk. So another common issue that we come across is employees being paid in goods and services instead of money or wages. So this is also known as payment in kind. So employers must be paid with money and can't be paid with food or drinks or store goods or accommodation, things like that, or other services. Separately, employers cannot require employees to spend their own money or wages on store goods either. But let's have a look at Josie's example here. So Josie works in a restaurant. On a busy night, her boss asks her to extend her shift by a few hours to cover the rush. And he offers to compensate her with a pizza for dinner instead of being paid for those extra hours. Now, particularly if she's part-time or full-time, that actually might be overtime as well. But She knows that this is not illegal and she needs to be paid the money correctly. So she shows her boss the Fair Work website, which says that she's got to be paid for money for all hours worked. Boss apologises and they pay her the overtime pay for the extra hours. And again, you can visit fairwork.gov.au/pay. We've got more information on the making sure you're being paid all hours as well. And I've got one more example to go through with you now. And this is the dropped plate. So the last myth is, and it's a really common one, unfortunately, particularly if you are working in that sort of hospitality area as well. The idea of that, you broke it, you bought it. And this is otherwise known as unauthorised deductions. So in most cases, money cannot be deducted from your pay for things like breakages, till shortages, or where a customer doesn't pay. Employers can only make deductions from an employee's pay when the employee has agreed to it, and the deductions are mainly for the employee's benefit. Now, if you are under the age of 18, then your parent or guardian must also authorise any deductions in writing. Some awards and agreements have extra rules about deductions. So again, it's always a really good idea to have a read of yours if there are any deductions happening. And of course, you can always get in contact with us, or you can just visit our website, which is fairwork.gov.au/deductions. And again, we'll provide you that link either in the follow-up email or in the description below. But let's just have a quick look at Ahmed's story here. So Ahmed's working in a restaurant. On one shift, he accidentally trips over and spills a meal all over an empty table. Now, he's worried that the cost of the meal is going to be taken out of his pay because he's made that mistake. But his boss explains rightly that mistakes do happen and it won't impact his pay. So he doesn't deduct the money from that pay. They clean it up. Everything's good. This is a good scenario. This is what we want to see. Unfortunately, not always the case. So let's have a quick look now at some red flags when you are starting work. So firstly, when you are looking at job ads, often the less details there are, the more concerning it is. So a really good idea to make sure you know who you're applying with and make sure that you're able to get sufficient details about the business before you start. Like we said, getting the ABN, getting the business name, the location, really, really good idea. Another concern is always going to be where an employer is not providing pay slips, even if you're asking for those. As I mentioned earlier, pay slips are going to give you that you're going to be able to check what you're being paid, make sure you are receiving the correct entitlements or things like penalty rates or allowances. And if things are going wrong, they can become evidence. So not being given pay slips can often indicate, not always, but can often indicate things aren't being done above board. Same with being paid cash in hand and where the business isn't keeping records. With that, we'd always recommend that you are keeping a record, even if you're just keeping a guide to the rosters that you're working and keeping a note of what money is going into your account. This stuff can be really helpful if things go wrong and your employer isn't keeping the right records. And of course, when you are working, a lot of awards do have meal breaks and rest breaks that you have to take, so that you have to be given. If an employer is not allowing you to take the meal breaks or is denying you meal breaks or rest breaks, it's often a sign there could be other things that are going wrong there as well. So that's another red flag that we would say if that's happening, maybe there might be more issues. But it's all well and good knowing what issues to look out for. Where can you get help with these issues? So if you do face any workplace problems or have any questions about workplace rights, you can contact us. We are responsible for ensuring workplace laws are complied with and provide free help and advice to employees and employers. It is understandable that you or someone you're helping may be worried about asking questions or making a fuss or complaining about what's happening at work. But it is okay to ask for information or help. It is against the law for an employee to be treated differently or have their shifts cut or to be sacked because they have asked about pay or other entitlements or because they've contacted us, the Fair Work Ombudsman. When someone contacts us, their information and concerns are not shared with the employer unless they want us to. As a first step, we usually recommend attempting resolution with your employer yourselves. So this can often be a great way to fix any workplace issues quickly. We do have a free online course on our website called Difficult Conversations in the Workplace. Course takes about 30 minutes, and it's a bit like a choose your own adventure, but it gives you the skills and some much needed information to have those difficult conversations with your employer. However, we understand this is not always going to be the best course of action. So if self-resolution doesn't work, or the situation doesn't make self-resolution a viable option, then you can seek assistance from us directly. So you can raise an issue by either calling the Fair Work info line on 131394 or making an inquiry via My Account. You can also submit a request for assistance. We can then assess what assistance we can provide to you to help resolve your situation. You can also report any problems anonymously through our anonymous tip-off form on the website. And while this doesn't guarantee any kind of immediate action, it does help the flow form understandings of where potential hotspots of workplace issues exist, whether that's by industry or geographic area. And often this can lead to some of our more proactive work where we go out and inspect businesses as well. If you do find you've got an issue, though, our website has a section called Workplace Problems. It's a really good first port of call, and we'll step you through what you can do in different situations and the best course of action, and of course, how you can get help from us. Now, for those of you who are on student visas, the Fair Work Act applies equally to all workers, including visa holders and migrant workers. I said that at the top, I'm saying it again. You have the same rights and protections as other employees, regardless of your citizenship or visa status. The Fair Work Ombudsman provides free information and resources to help you understand your workplace rights. Your rights can't be removed by contracts or agreements, and we make sure workplace rights are protected and enforced fairly under the Fair Work Act. As I've just said, you cannot get into trouble or even have your visa cancelled for contacting us. Employers cannot cancel your visa, even if you breach your visa conditions. Only the Department of Home Affairs can grant, refuse, or cancel visas. So the Australian government has introduced 2 pilot programs to support visa holders facing workplace exploitation. Both pilots are being administered by Home Affairs. So there's the Strengthening Reporting Protections pilot. So under this pilot, Home Affairs won't cancel your visa if you breach work-related conditions and you meet certain criteria, including that you provide Home Affairs with a workplace exploitation certificate. And there's also the Workplace Justice Visa pilot. So under the Workplace Justice Visa pilot, you may be able to temporarily remain in Australia if you meet certain criteria, including that you provide Home Affairs with a workplace exploitation certificate. So the Fair Work Ombudsman and other accredited organisations can issue the workplace exploitation certificates. If you've experienced workplace exploitation, it's a difficult one to say. You can contact us, and after we assess your situation, if we find potential non-compliance with the Fair Work Act, a Fair Work inspector may issue a workplace exploitation certificate stating that you've sought help for a workplace exploitation issue and that we are investigating your case. The workplace exploitation certificate is not a recommendation to Home Affairs to grant a visa or protection from cancellation. If you do decide to apply to Home Affairs for one of the 2 pilots, definitely a good idea to visit their website for more information about your eligibility and how to apply. Now, we're nearly at the end of today's webinar. If you have enjoyed this and you'd like to learn a little bit more about your rights and entitlements, then I would encourage you to check out our Employee Guide to the Flows Tools and Resources webinar. So it's currently available on our YouTube channel, which is Fair Work, well, it's on the screen there, Fair Work Gov.au, and we'll show you how you can look up award pay rates and other entitlements. YouTube also has many other webinars like this one that you may find useful. So if you are having a look at issues at work and you'd like to know more about how to go about resolving that issue, we also have a webinar on resolving workplace issues for employees as well. So definitely keep an eye on that one. And of course, if you have enjoyed today's webinar and you want to watch it again or share it with your friends, this will also be on the YouTube channel shortly after the live broadcast. So that's pretty much all we have time for in this webinar, and I hope that it has been useful in giving you a baseline understanding of your rights and entitlements as you embark on your job searches and applications and your future careers in general. So if you do have any further questions or would like to get in touch with us regarding workplace entitlements, you can do so by going to the Fair Work Ombudsman website, which is fairwork.gov.au. You can contact us on our info line, which is 131394. And if you do need translating and interpreting services, you can contact us for free through that service on 131450. I've also popped up a couple of the useful pages there, particularly for young workers and international students. Once again, this will be in the email and in the description below, so don't worry too much about taking that down. We've also got our social media details on there and where you can put an anonymous report as well. We do also regularly tailor webinars for different audiences. If you'd like to see what we do have coming up, you can visit our dedicated webinar page at fairwork.gov.au/webinars, and that's got information about upcoming webinars and also a portal for what recorded webinars are available as well. For those who have joined us live today, there will be a quick survey after the webinar. We'd really appreciate it if you could answer a few questions. It'll really help us develop our webinar program. Should only take you a couple of minutes to complete, and we really, really value your feedback, and it really helps us to make these as useful as possible for you. So thank you again for joining us today, and we really hope to see you at another webinar in the future, and the best of luck for your semester.